It's attorney Ashley Goggins. We are at day 9 of Free Game Friday for 12 days of Christmas. Listen, I'm so excited. Day 9, 3 more days to go. Today we're going to be talking about mediation, but before we get started, I'm going to go ahead and share this out. You take the time to do the same. Tag someone below, a friend, family, coworker, whomever you know that may need this information. Maybe they have a mediation coming up in their family law case and don't know what's going on. So I'm going to share this out on my page and we are going to get started. Okay. Thank you guys for tuning in. If you tuned in every day, I appreciate it. I appreciate all of the comments, the love, the likes, and the shares. It is greatly appreciated. I am going to continue to show up and give you guys this valuable information if you are navigating a family law case. So let's get started. Mediation. Mediation is mandatory in family law cases. You are required to go. You are not required to reach a settlement, but you are required to go and make a good faith effort to try to resolve your case. So the court is going to order you. By the court, I mean the judge orders the parties to mediation. What is a mediator? A mediator is a Florida Supreme Court certified mediator. Generally, they're going to be a lawyer who is going to be impartial, neutral, and try to help both parties see the pros and cons of their positions and writes out an agreement if you guys come to an agreement and submits it to the court for the court to sign or to make a formal final judgment. So mediators are generally lawyers. They don't have to be a lawyer, but they are certified by the Florida Supreme Court to help you resolve your case in a manner that is not before the judge. So it's a non-adversarial procedure. In mediation, everything is confidential. Everything is confidential in mediation. So if you do not resolve your case and you don't reach an agreement at mediation, you cannot go to trial or go to another hearing and say what happened in mediation. So if the wife is offering you equal time sharing in mediation, but you guys can't agree on some of the issues, so you guys don't agree to anything and you have to go to trial, you cannot say at trial that she agreed to equal time sharing at mediation, so why is she trying to get majority time now at trial? You cannot do that. That is absolutely against the rules of confidentiality and it will not be tolerated in court. So with mediation, like I said before, you are required to go, but you are not required to reach an agreement. No one is going to make you reach an agreement, but it's a good time to reach an agreement because both parties will have a say-so in what happens. If you go to trial, obviously it's going to be up to the judge. The judge will make the sole determination of what happens, what the final outcome is. When the parties reach a settlement, both parties are signing, both parties are negotiating, both parties, it may not be everything that you want, but both parties are involved in what happens. Both parties are putting their input, and no one can make you agree. No one can force you to agree, but you have a say-so in what happened. At trial, you never know what may happen, so you don't always get to choose the outcome. You don't get to choose the specifics of the parenting plan, whereas with mediation, you may want a clause in the parenting plan that a judge absolutely would not do. And generally, your attorney will tell you like, hey, you might want to resolve here because a judge is not going to give you that, but if she or he is willing to agree to that clause, I would say you would want to get that clause written down and settled here because a judge absolutely would not do that. A lot of things with relocations, judges will not do prospective relocation. So a judge will not say, oh, if you decide to move in the future, XYZ. That's called a prospective. But in terms of a settlement agreement or a mediated agreement, you can agree to prospective relocations if you want to relocate. Also, deviations in child support. Sometimes you can get a deviation by agreement. One party gives up something, the other party gets something, and vice versa. A lot of times you would have to file a motion for a deviation if you were to go to trial. Sometimes you can, or a lot of times you can waive child support if it is what we call de minimis. That it means that if it is a minor amount. So let's just say if the guidelines come out to be $7, generally the court will have to award the $7 a month. But a party, a husband and a wife, or a mother and father, they can say we're going to waive it. Each party takes care of the child when the child is in their care. So there are a lot of things that can be settled in a mediation versus a trial, not so much, because the judge is going to do only what the law requires him to do or her to do. They don't go over and above. I find that sometimes final judgments with the court are not as specific. You can get real specific in a parenting plan. I'm talking about school clothes. Like, that's a big contested issue, is that if a party pays child support, they don't have to, bust down with you on school clothes, on school supplies, on fees at school. They're not required to do any of that. Sometimes people ask to put that in their parenting plan, and if the party agrees, then that's fine. However, a court or a judge is not going to require the paying party to do that. So this is why you want to kind of agree, and it's best to agree. And generally 70 to 90% of cases are going to resolve at the mediation stage. So they'll resolve here, versus the other, 10 to 15% would go before the court. Because sometimes, and I'll be honest, people are just completely unreasonable at mediation. Completely unreasonable. And I find that the most unreasonable parties are parties that are unrepresented, because they don't know what they don't know. So my client may be making an offer that the court will absolutely give that party in terms of time sharing, and the other party may say no. And I know as an attorney, like, well, the court, that's the bare minimum of what the judge would do. But the other party may not know that information because they're not represented. So let's just say your case resolves at mediation. You reach a mediated settlement agreement. What happens next? So what happens next is that mediation settlement agreement is ratified through a final judgment by the judge. If you are married, you still have to go and have the quick hearing that is required by law. And so you have your quick hearing. Only one party has to show up. One party can waive their appearance. If it is the wife and she is requesting a name change, she has to be present. If it is the petitioning party, generally they are the party that goes. So the party that filed first, they go. Again, that can be different if the petitioning party is the husband, but the wife is getting a name change. Both of them would generally go, or the wife can go on behalf of both of them since they've reached an agreement. If you are not married and this is a paternity or time sharing action, then you can, if you are not represented, then generally you would still have to go to a hearing. A hearing would be scheduled by your case manager that you receive. If you are represented, then a consent final judgment ratifying the mediation agreement would be submitted to the court. As long as you've taken your parenting class and done all the other requirements, the court would enter the final judgment ratifying the mediation settlement, and then the case will be closed immediately. If you don't settle your case in either event, whether you're married or not married, the case will proceed to trial. And then it'll be up to the judge. Lastly, how much is a mediation? Each circuit in the state of Florida has a mediation program. Basically, it is a state program for the county, and you pay based on your sliding income scale. So for our counties, generally, if your income is under $50,000 combined, you pay $60 a piece. That's it. It's not an hourly rate. It's just a one-time fee. If it's combined over $50,000, then you're paying $120,000. I'm sorry, you're paying $120 per person. That is for the state mediation. If you are unrepresented, both parties, you're generally going to go to, we call it the family mediation unit or courthouse mediation. However, if there are attorneys on the case, you're generally going to go to private mediation unless the combined incomes are so low that you guys cannot afford it. But generally, if you have counsel, the court will require private mediation because there's a better likelihood of resolving the case because you're paying an hourly rate. You have a vested interest in actually resolving the case because now you're expending resources based on the time that you're there. So mediators charge anywhere from $175 an hour to $350 an hour. And so not only are you paying your attorneys to be there, you're also paying the mediator. Generally, that mediation cost is split equally amongst the parties unless the judge has required another payment schedule. Or the parties can negotiate who pays during mediation as well. So that is mediation. It is the best stage to resolve your case, no matter how contentious the case has been, no matter how emotional the case has been. It is the best time to resolve your case because that is when you have a say-so in what happens. I will see you guys tomorrow for day 10. Don't forget to share this out. Let me know if you're watching the replay. Tag somebody below if they need information on mediation. See you guys tomorrow.